Hi, Bill Henshaw here again. Think of this as A Beautiful Mind Part 2 with John Nash. And the important element I should have mentioned in the first video is we're in an unprecedented window of opportunity here, especially in the last year and a half or so, since the U.S. Supreme Court has begun to act like an Article 3 judicial court for the first time in 90 years. I get it. I know what they're doing and where they're going, and I can talk a lot about that a cappella also, because some of the recent cases, and here's a biggie for two reasons: Texas v. California, where they refused to file documents for the state of Texas against California, and in what looks like a two-justice dissent, Alito and Thomas upbraided the court for doing it and reading between the lines, and I'm pretty damn good at doing that after 40 years. They suggested one of two things. Either the Supreme Court has the power to amend the Constitution, which I heretofore thought was lodged in Article 5, or state doesn't mean state. That's the crown jewel of every issue I do. There are no sovereign, independent states remaining which were admitted into this union. And they almost as much came out and said that to the discerning reader, as to why they were not able to file the documents, because Article 3, Section 2, read it. What does it say? In all cases, A-L-L, in which the state is a party, the Supreme Court has original jurisdiction. And that's been the major department of government over the course of the last 160 years. State doesn't mean state. And I've never yet gotten to see a jury. I may never see one, because you go up there with arguments like that, and I can explain it to a jury very easily so they'll understand it. It won't take them a long time like it took me to understand that key point. They're not there. They get it, and they've been doing other cases. Oh, let me get back to the Texas case first, because they cited in their case called Cohen's v. Virginia. 6-week 264, 1819, I believe. Oh, that's old law. Nobody uses that anymore. Well, they did it for a reason. And some of the citations out of that Cohen's case, and here's a dead bang verbatim one. The Constitution gave to each person the right to present his case to the court of the nation. No matter how small the claim nor how little interest the community in its outcome, the framers of our Constitution thought it important in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. Now you try to go in there and file documents in a trial court, aka administrative tribunal. In my jurisdiction, such as it is, you now need an appointment to do that with the damn county clerk, or the clerk of court, I should say. Absolutely ridiculous. They're there to serve us. They're our servants. They're there for our convenience, and they're going to tell us what to do if they file it. And as often as not, you will learn that the documents can't even get filed today. And that's a dead bang giveaway about not only that there's no states, that we're not in a judicial court. We're in one of those administrative tribunals, and we can prove every bit of it. And if that's true, that makes every law on the books null and void, nunc pro tunc ab initio, as at least a bill of attainder. The taking of life, liberty, or property without judicial process. And the Supreme Court at this moment in time, with my research, hasn't made a serious ruling on that issue since 1867, Cummings v. Missouri. That's not accidental, as you'll learn by studying my materials and helping me get the word out to other people as to exactly what happened and why. All they have now is a due process bullshit from the 14th Amendment. Doesn't mean a damn thing. As I said earlier, that amendment not only doesn't exist, it never has. It's totally worthless, all you civil rights advocates out there. We got to get rid of that as quickly as we can. And all the other amendments, all we really have, as you'll learn, are 12 amendments in any event, not 27 like you've been misled to believe all your life. 12. That's it. We get back to that point. We make real progress. We make it quickly. and we get our nation and republic back. And that's what it is I want to do. Another key quote from Collins, not a verbatim one this time, but the court said, and this, by the way, is by Chief Justice John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? Speaking for a unanimous court, and said, in effect, the court must exercise jurisdiction if it should, but it can't exercise jurisdiction it doesn't have. The one or the other is treason to the Constitution. And that's a major, big area for us to start beating these bastards, because we then file cases, which I'm attempting to do right now, in court, and charge them with that. Because in theory, at least, they have a sworn oath to be bound by this Constitution and laws enacted in pursuance thereof. Article 6, Section 2. If they don't have that oath, they're not in a judicial court. They're almost certainly not in a state court, and we don't know where the hell they are. And among other things, they certainly don't have any contempt powers. See you later with that claim. Doesn't exist. So these are the points that we need to get in and start making, and as many people as we can get up to speed in a hurry to start doing this, especially in smaller states, the quicker we get there. And not only that, we teach them so they can teach their children and their posterity, and not have to rely on the mandatory public education system like I had to do 50 odd years ago. And by the way, it was a lot better in some ways in that era, because for me, it was the Montgomery County Board of Education. It wasn't all run out of Annapolis. So you had much more control than you do now, and especially with all this LGBTQ crap and transgenderism and this, that, and the other. And by the way, one at the same time, here's another major big issue. How can these bastards run these school boards say that a second or third grade child is competent to make a determination that he's transgender, quote unquote, whatever the hell that is, and at the same time, and you've probably experienced this, you'll walk into one of their courts, they presume that you're not only incompetent, but ignorant from day one. Which way is it, and why? And let me add another important point here from Bouvier's Law Dictionary, 1859, and I have one, not the original, but I've seen the original from which it came. Citizen, the definition from Bouvier's: one who can vote for representatives and all other government offices, and who is competent to fill all offices in the gift of the people. Wait a minute. In that era, we were presumed competent across the board, and now we're considered, nothing better than incompetent, if not ignorant. And it gets worse than that, because the real deal here is that the governments in all these state capitals think that we're in a guardian and ward situation. And there's no possible way that could be right, because if they're going to tell us at one and the same time that they have total control over us, as the guardian, and we can't appear in any of their courts except in a matter challenging the administrator we have, one and the same time, if we're incompetent, then you start asking these people, how is it that we magically seem to regain competence every 2 or 4 years on election day? This is how bad it gets for them. They don't have any answers. They've never had any, and they can't create any. There's none consistent with the original intent of the framers. So that's how good it is. And as I say, events in the Supreme Court, and they just did another case called U.S. v. Madero, M-A-D-R-O, a case coming out of territorial law. That old arcane stuff, nobody knows that. Happens to be a special area of expertise for me. Not only did they sound exactly like me in this case, but from exactly the same reference book I use, and this one was 8-1, not 5-4. They get it. That means when we get our issues there, they're going to have our backs on a lot of these issues. Maybe not all of them initially, but a lot of these issues, and big changes can now be made. And we can do it through the Judicial Department of Government, which isn't subject to control, despite the fact what's going on with Congress right now, another court packing plan. More about that on another occasion. But that said, these are important points that I need you to know. And the Fifth Circuit, by the way, the most conservative Court of Appeals in the country, is doing the same thing. And I'll talk to you more about that later too. And big case out there that you'll see exactly where it's going, and I do know what I'm talking about, and they do get it behind the scenes. It's really exciting stuff. That's why my life at this age is still ahead of me. It's astounding. With that said, feel free to contact me, uwinnincourt@gmail.com. Serious principles only at 650-267-9350. We can go a long way in what looks like a really short amount of time, and get big efforts here to make changes in the government that we will actually maybe still be alive to see happen. And I would love to see all of it happen. Whether I get across the Red Sea, I don't know at my age, but I got a good 8 or 10 years given what family history has been to this point. And I'm working day and night to get the job done. That said, be sure to tell your friends, spread the word, like the videos. And as I say, contact me, uwinnincourt@gmail.com. Serious Principles 650-267-9350. Thank you.